I bet Miss Walker never called you back either, did you? Neither. So I'll tell you what we could probably go ahead and do, because we know that the conflict or the C3s aren't gonna be here, right? Ms. Rhonda,
Yes.
but you know of those, I think it's just the two, right? Rice and Quarles.
Yes, I have not received an update as to whether or not an attorney is going to sign either of those.
Yeah, and she didn't call me back, but I'm gonna try to call her again. I'm
Good
gonna find out.
I did check in with her and she told me she was in court this morning, so that may be why she was unable to answer your phone call.
Yeah.
Good afternoon, Your Honor.
Hey, how are you, Miss Amy?
Good, how about you? I'm actually representing Leo Rice.
Are you gonna do Ryan Quarles too?
Oh.
I was not aware of Ryan Quarles.
Do you want the case number? To see, because there's two for C3. Leo Rice and Ryan Quarles.
Hey,
How many people do y'all have left
Hey,
in your
Valeria.
office? Two?
I think
Hey.
this is gonna be an issue then. You said you have Leo Rice.
Mm-hmm.
Well, we also have Latrell Honeycutt, who is co-defendant in the same case.
Okay. I think I talked to Ms. Walker about it. She said that it was okay for me to represent Rice. I think Mr. Lyle withdrew. And so
He's
they're gonna,
gone. He didn't work here. He withdrew from working.
yeah. So they're gonna close out Honeycutt.
Okay, so he will need a C3.
Yes.
Okay.
So who's gonna need the C3 Honeycutt?
Sounds
Yeah.
like.
Well, that just stole Mr. Cash's thunder then.
It did.
So are you sure that one's gonna need a C3 instead of the other one?
Yes, Your Honor.
What you gonna do, Mr. Spencer?
I guess.
Wanna come up here? Swap plays with me?
Well, no. You can stay there. I trust you.
No, this is for inspection probable cause.
Did we have somebody here for Honeycutt? No? Do you?
One incident.
Oh, okay. So King. Which other one? King, Honeycutt.
King, Honeycutt, Quarles, and Rice.
All right, so we could do Rice. Well, Miss Rhonda, you only got one. So we can take Deion Watts whenever. Well, there's nobody here for Deion Watts. But it's 104. Number two, get anything from that person?
That's for, to Simon, he just got called to a shots fired.
A shooting call in the city of Atlanta, no way. So Miss Rhonda, do you want to still hear him on bond since he just got called out for something, I guess?
I apologize. So he got called.
Got called for a shot.
Okay. Understood. I would like to be heard on bond today.
Okay. And then what reset date do you want for that one?
I have options.
Ms. Watts, what are her options for reset for Watts? Your brother, what is it, really then?
June 20th at 1 p.m.
Gotta look at your calendar. Are you good?
Well,
Actually, that's a great idea, Your Honor.
Oh, and we're also checking, let whoever know, Ms. Celeste, that we are checking because during the PAC conference, what is it, July 17th, 18th, 19th? I think we're just not going to have prelims or anything because I think most people are going.
I think you just allowed me to go.
Right? Yeah, I think most people are going, right? 17th. Yeah, because we were just talking about it yesterday. So I had talked with Miss Gaston last night and Miss Lewis. And I think we're going to just not have night court or prelims on those days since PAC. Don't y'all have a conference too, right?
We do, it's in July,
What are those dates?
July 17th through the 20th.
So,
Okay, that works.
but y'all's is through the 20th. Is it include the 20th?
I think it's over the morning of the 20th.
Oh, okay. So same date. So it'd just be easier just not to have anything 17th, 18th, 19th, right?
Yeah, because our conference is out of town all day.
Where's y'all's?
Athens.
Where is y'all's in Savannah? Is PAC in Savannah?
Jekyll.
Jekyll, okay. Y'all go to Athens, they go to Jekyll.
We have fun.
We gotta keep it separate.
That's true. Yeah, so I think I'll have to, Miss Lewis, are you on yet? Oh, I guess she's not here.
That June 20th date works.
Okay. 1 p.m.
Yes.
Let's see. Now, on the 20th, does that mean would y'all need off, what's the 20th? Is the 20th a Wednesday? Hey, so the Public Defenders Training Council also has training that 17th, 18th, 19th, and theirs goes over half a day on the 20th. So yeah, probably no prelims. Yeah, so both of them at the same time. So on the 20th, do y'all have stuff, Miss Rondon, or
June 20th? No.
July 20th?
Oh, July 20th. I believe it's like a conclusion breakfast that morning, but I don't believe after that, we're free to go and come back.
Oh, okay. So would you say like on the 20th, just have an afternoon prelim calendar?
Yes.
So how about that? On the 20th, just make it an afternoon prelim calendar. Right. Yeah, I think night court would be okay on the 20th, don't you think?
I think so.
Yeah, night court will be fine on the 20th, just not morning prelims. So nothing on the 17th, 18th, 19th, and the morning of the 20th. Afternoon of the 20th and evening is good. All right. Yeah, because that's the Public Defenders Council and prosecutor attorney. So that's good. It's at the same time. Exactly. All right. So we'll just knock that out and that way they can all go. All right. Thank you. All right. LT, we got much longer. I know we can bring one guy for bond hearing. How about Dion Watts? Dion Watts, and then we can get you where you've got two. You've got say it one more time. Bryce and
I have Rice, Quarles, King, and Huntington.
okay, Bryce. So, Mr. King, Mr. Lumba.
How you doing, Judge?
Hey, so so some of your people are all maybe on Mr. King and Mr.
Dodd.
Let's see, so you got Mr. King, Mr. Rice, Mr. Quarles. They're all co-defendants. And Quarles, Rice, and King. And Honeycutt are all co-defendants. And you represent King and
Yes, I represent DeAndrew King.
is that the only one you represent?
Yeah, on that case, yes, and I represent Alfred Dodd too. On I forgot what position
Dodd's
he
not
was.
in that though, right? Dodd. See through. They could. All right, so after that, we'll call the other case out we'll get out Mr. King and well, not Mr. Honeycutt, but Mr. Rice.
Mr. Watts.
All right, Ms. Hollenbeck, this is just going to be a bond hearing. We're going to reset this one, sir, so the officer can show up to June 20th. Is that 9 a.m.?
1 o'clock, I think.
Is it 1 p.m.? So this is position 22 CP 211410, 300 days without indictment. Got a charge of armed robbery. We are going to do a bond hearing on this. And let's see, do we have a bond yet? Catch up, Alex, catch up.
Try to get your bond release.
1 second.
Yes, he has a bond on the May 16th.
Yeah, how much? Let's see. Oh, $25,000 good bond on May 16th. Well, let's go.
This is Mr. Watts, Your Honor.
Yes, ma'am.
He has 23 cycles. The last arrest was May the 31st, 2022 with the City of Atlanta Police Department for battery and reckless conduct. There was no disposition for that arrest. He does have prior felony convictions. This one in 2012 for possession of controlled substance with the intent to distribute, and one in 2003 for possession of controlled substance. And he has misdemeanor convictions, one in 2021 for possession of marijuana less than an ounce, one in 2014 for simple battery, and one in 2013 for a DUI. He does appear to have a history of probation violations. There's one in 2020, and one in 2017, and one in 2015. Nothing in addition, Your Honor.
All right. Go ahead, Ms. Rondon.
Yes, Your Honor. Mr. Watts is 35 years old. He is born and raised here in Georgia, and he's lived in the Atlanta area his whole life. He does have all of his family here in the area, to include his 2 children, ages 7 and 16. Mr. Watts did make it to the 11th grade at Washington High School. Prior to being arrested, he was working at Powers 27, which is a moving company. He had been employed with that company for 3 years, but he's been in the moving industry for 15 years. He does have a good address. I believe it is, I can double check to make sure it's the one on file, but it is 2591 Center Street, apartment D219 in Atlanta. He would be able to live there with his girlfriend, Deshandra Wilson, and their children. Mr. Watts has been in custody for 300 days by my count. His current bond is at $25,000. Had we been able to have the preliminary hearing today, I believe Your Honor would have heard facts that would greatly put this charge in question, whether or not there was probable cause. I would ask, because of the significant period of time that Mr. Watts has been in custody, for his bond to be reduced, and I am asking for it to be cut in half. So bond to total $12,500. We will be okay with the conditions previously set by Your Honor back on May 16th. That includes the no contact, the ankle monitor, and curfew.
All right, what says the state?
Can you hear me?
Can you hear him out of court reporter?
Yes, I can hear.
Okay, thank you. Your Honor, the state would ask that the bond put in place is more than fair and reasonable considering the nature of this crime. This defendant poses as a danger to the victim still, as this was a violent crime. The defendant also has previous violent history in his pretrial report as read out by pretrial. Therefore, this defendant has a significant likelihood to reoffend. Also, I think pretrial mentioned 3 probation violations. That in itself lends itself to a likelihood to reoffend as well, as he's not following his probation as he is supposed to. 25,000 in this case is more than reasonable. In regards to the incarceration time, as you know, the state has a statute of limitations on window indict, and we have not met that yet. So at this time, we feel a 25,000 bond is fair and reasonable, and we would ask that Your Honor leave it as such. Nothing further.
300 days without indictment. 300 days. Who is it? So Ms. Pinto always likes to repeat it like 97 times, right? So what's it looking like on indictment on this? Because you're not that far away from a year.
I can
Investigator Paul's trying to hand you something.
just a calendar.
Trying to hand you cliff notes.
I can definitely reach out to our indictment team so that I can get it done faster, but unfortunately, they are backed up. We have a lot of cases here, so I will
They're gonna
send an
start
email.
filing speedies.
Oh, yes, we will.
What are y'all gonna do when they're filing speedies left and right? I'm just curious. We can talk about that off the air if y'all want to, but I'm just curious what the plan is on speedies. All right, so here we go. No drugs unless prescribed, no alcohol, no weapons. Now, I don't always put you on the spot, but Mr. McCauley will tell you how I did that, all right? No further contact with your co-defendants. DeAndrew King, Rashawn Blue, stay away from 870 Mason Turner Road in Atlanta, Georgia. No drugs unless prescribed, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. No further contact with the alleged victim. Trevell, T-R-E, accent V-E-L-L-E, last name McCrae, M-C-R-A-E. Sir, that ankle monitor is going to be paid for by the county. By chance, if any hold or anything like that pops up, you'll have 48 hours to have that ankle monitor placed on your ankle. 300 days without indictment, though, $12,500. I think it's best, $300. Best of luck to you, sir.
Thank you, Your Honor.
So we need, So we need Rice and King, correct? Because Quarles needs another attorney. And what's the other one? And Honeycutt needs a C3 attorney. So LT, do you want to bring Honeycutt and Quarles out and I can tell them they need another lawyer, or you just want to send them back?
I did speak with Mr. Honeycutt yesterday, not knowing
Uh-huh.
the situation. So I would like for him to come out so I can explain.
So we can tell him.
Yes.
All right, so you can bring, right? I mean, you can bring Quarles and Honeycutt since they both have to be reset. And then we'll bring out Rice and King. So Mr. Luwamba, we'll take Rice and King, and then we'll do yours where he's a co-defendant with Rice, and then we'll move on to the next one, okay?
Okay, thank you, Judge.
All right. Hey, did you get our messages the other day where we missed a couple of prelims?
I did, yes.
Okay, just making sure. Did you just avoid it because it was me?
I did not, Judge. I love coming in front of you.
Okay. We didn't have a number, but at least now we got a number. I know everybody's being pulled everywhere, so.
Yes, Judge.
All right. All right, let's see. So this is position 523 CP 216419, Latrell Douglas Honeycutt, 434 days aggravated assault. And we got Ryan Quarles, 23 CP 216419, 437 days aggravated assault. So go ahead, Ms. Rhonda.
Yes, so I know we met yesterday, but it turns out my office and a different attorney already represents an individual in your case. And so it's a conflict for me to represent you today. So you, as well as your co-defendant over there, both of you need to be appointed representation, what's called a C3 attorney. That's being handled as we speak. So you should have representation by your reset date, whenever that's determined.
What
But
date are we gonna give them? Do we need to give them that July date too?
most likely.
July 6th, 1 p.m.?
Yes.
So July 6th at 1 p.m. I'm gonna reach out to them also to make sure that they don't lose us, okay?
Excuse me, Ms. Manning. I mean, is it possible I can represent myself? Because we ran into the same problem, no disrespect, we ran into the same problem last time. We're just gonna keep getting upset, cause these people don't even answer the phone. I can't even leave a voicemail on their phone. Seriously, we just keep getting upset.
Right, well, I'm as frustrated, well, probably not as frustrated as you are because I'm not in jail. However, I am as frustrated as you are in one aspect because this isn't the first time. So I'm gonna call them. I've got in a call to the lady that assigns them. And I'm gonna go ahead and push this up the chain and get this, because this is ridiculous, because besides just saying you want to represent yourself, there's something else you have to go through. It's called a Ferretta hearing. So you have to go through more before you can represent yourself, okay? But you have my word that I'm gonna reach out to Ms. Joy Walker today to find out what it is that's going on. Because to me, if you get a conflict, one should be assigned to you within at least 2 weeks. I mean, I know everybody's busy, but no one's any more busy than anybody else, okay?
It's been since February. I haven't yet to talk to anyone. No one have came to see me or anything.
Right. I understand, and I will make note of that and pass that on. I've already called her once and she has not called back, and Ms. Watts has actually reached out to her also. So we're going to try to get to the bottom of this because there shouldn't be such a lag at all, okay? I understand your frustration, sir, and I promise you, I am at least one thing I am is a person of my word. If I say I'm going to follow up, trust me. I've already called once and I will call again as I'm on my way home to go do night court. I will call again and make sure I get in touch with Joy Walker and find out what the lag is in getting some of you folks C3 attorneys, because you shouldn't be sitting in there that long without being able to be heard. But like Ms. Rondon said, a C3, so they have a conflict attorney. So if the public defender has a conflict because they represent somebody, they have sent to the conflict. Well, then when the conflict attorney has it, then it's called C3. So it's like, it's a conflict for them. We actually probably need C3, C4, and C5, the way things have been going on today, but we'll get you back before then. And I promise you, you have my word that I am going to reach out to Ms. Walker today and find out what, and Ms. Rondon has been reaching out too. She reached out prior to this hearing to see what it is. So we're all checking. Okay. You got my word. Is that are you back there for one of these? Okay. Y'all aren't. Okay. Mom, no. Okay. So I'll get back to you. I promise. So we'll see y'all in July.
Your Honor, I would ask, if possible, that Mr. Honeycutt could be heard on a bond motion today. We'll represent him only for the purposes of the bond hearing, and after today, he will be represented by a C3 attorney.
And I guess we can't do that for Mr. Mr. Quarles, huh?
I've not spoken to Mr. Quarles, but I did speak to Mr. Honeycutt last night before I was aware of the conflict situation. So I was prepared to ask for a bond reduction today. I have those notes available.
Would it be too much of a conflict for you to see if you can speak with him, see if you can do a bond or no?
I think I could represent him for bond purposes.
Only just that, and then that way we won't steal your thunder there. Do you mind?
I think
Right.
that-
I don't want it to be just bond. So what if she's going to do that? She only wants to hear certain things. Contacts to the community, how far you went in school, stuff like that. Don't talk to her about facts about the case, okay? Do you want to let him do that one? Mr.
Sure.
Spencer?
I'll go ahead and do both of the hearings.
You sure?
Yeah.
Okay, you want to help her? You can help her. I have the utmost faith. Utmost faith in you there, whichever. You got up, put a big old suit on, he's ready to go.
Your Honor, do you mind me approaching the jury?
No, that's fine. And that way, Ms. Watts, maybe we could email Ms. Walker. I think Ms. Rondon does. Well, Ms. Markowitz sent it. I'm not sure. She wasn't sure which it was. Let's see. Can you give us, is her email, let's see, hold on. Is it first dash last name at georgiapublicdefender.org? Or is it gapubdef.org?
It's fully spelled out, Georgia or GApublicDefender.org.
Okay, so here it is, Ambria. I'll send it to you. Maybe you can put her like all of them and just say that we asked because we got a lot of people sitting here. I just texted you.
And I will present.
Are you sure? I don't want somebody to do something that's not just strictly bond.
Yeah, this is strictly bond. I'll represent Mr. Honeycutt only for bond purposes. And
Okay.
Mr. Cash will present for bond purposes for Mr. Quarles.
Okay, so we'll go ahead and hear on bond for Latrell Douglas Honeycutt, 23 CP 216419, 434 days without indictment, aggravated assault. Retrial.
He has 21 cycles. The last arrest was March the 28th, 2022 in East Point, Georgia, for battery, family violence. There was no disposition for that arrest. He does appear to be on probation in Fulton County for 3 counts of aggravated assault. That case number is 22 SC 181187. That disposition date was February the 23rd, 2023. And the term is for 6 years. He does have prior felony convictions. One in 2017 out of Clayton County for criminal attempt to commit a felony. And one in 2013 out of Muskogee County, Georgia, for crossing state, county, or guard lines with intoxicants and drugs without consent. And he does have misdemeanor convictions. There was one in 2013 for simple battery, family violence, and criminal trespassing. And he does have a history of failure to appears. There was one in 2018 and one in 2017. Also, he has a history of probation violations. There was one in 2022, one in 2018, one in 2017, and one in 2016. Nothing in addition, Your Honor.
All right, go ahead, Ms. Rondon.
Yes, Your Honor. Mr. Honeycutt is 29 years old. He is born and raised here in Atlanta, and he does have his whole family here in the area, which includes his child, a girl that just turned 1 year old. Mr. Honeycutt has a 9th grade education. Prior to his arrest, he was working with a temp agency. He was trying to find a position that he was a good fit for. He is an active member in his local church and does, as a part of that membership, participate in some scouting for sports. He does have a good address. That is 3060 Kentucky Court, apartment 8 in Atlanta, where he would be able to reside with his mom. He does have an MH diagnosis, but it is my understanding that he has not been receiving his medication while in custody, although he has asked for his medication. This is definitely an issue and a very concerning issue at that. I think his family has gone down to Rice Street to ask for the medication to be given to him and have been unsuccessful with that request. I do believe he will be better served out of custody where he can properly take his medication and receive whatever services that he needs for that MH diagnosis. His current bond is set at $25,000 for the 1 count of aggravated assault. This is a jail incident. I would ask for his bond to be reduced. He has been in custody. My math may be off, but it's over 430 days, which is 434. That is an extremely long time. And taking that into consideration, I would ask for his bond to be cut in half and for bond to be set at $12,500.
All right, what says the state?
Yes, Your Honor. The state would ask that you not reduce the bond at all. This defendant has received a bond as he is entitled to of $25,000 based upon the defendant's history of violence. And I think pretrial mentioned just multiple FTAs. One, this defendant serves as a significant likelihood to reoffend. Secondly, there seems to be a risk of fleeing since he does have so many FTAs. The state would ask that you keep the bond the same as stated previously because it is fair and reasonable. However, if your honor is inclined to lower the bond, we ask that it be no less than 20,000 with the same conditions put in place. I would also add that this is a jail incident, so I would have your honor note that while in jail, he still is having violent offenses charged to him.
All right.
Nothing
No
further.
drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. No further contact with your co-defendants, DeAndrew King, Leo Rice, Ryan Quarles. If there's any kind of hold, you have 48 hours to have that ankle monitor placed on your ankle. And if you move, you have to let the county know where you're moving to. So you have to keep your address up to date, just like the other person. $12,500 good bond. Best of luck to you, sir. All right, bring it on up, Danny. What you got, sir? Interrupting court. No, let's see. What's it? See, just one or two. Thank you, sir. Good to see you. All right, now we've got Mr. Quarles. You ready, Mr. Spencer?
Yes, Your Honor.
Sure?
Yeah, I'm gonna give it a shot.
Okay. All right, 23 CP 216419, Ryan Quarles, 437 days without indictment. We've got one charge of aggravated assault, and there's probably, if I had to venture to guess, $25,000 good bond.
Yes, ma'am. That's right.
The defendant has 12 cycles. The defendant's last arrest was July the 14th, 2021 in Pennsylvania for criminal conspiracy and possession of instruments of a crime. And it was a misdemeanor in simple assault and aggravated assault. Those charges were null prossed on March the 11th, 2022. The defendant does appear to be on probation in Fulton County for 2 counts of robbery. That case number is 18 SC 159472. That disposition date was March the 21st, 2023. And the term is for 8 years and 6 months. He does appear to have an outstanding hold out of Dahlonega, Georgia, for a failure to appear. The date on that warrant was June the 8th, 2022. And he does appear to have 1 misdemeanor sentence. It was in 2016. He received a nolo contendere sentence out of Gwinnett County for an expired tag. Nothing in addition, Your Honor.
Looks like actually he's no bond. Go ahead, Mr. Spencer.
Thank you, Your Honor. So this is Mr. Quarles. He is 28 years old and he finished high school in Pennsylvania. I know pre-trial mentioned that he was from that area. He moved here for work, but before he did that, he did finish high school. He went to St. John's for 3 years. Part of the reason he wasn't able to finish that was because his aunt passed away and she was helping him with financial aid. And as we all know, student loans are expensive. It's just hard to make that work. And so what he did is he was able to move to Atlanta, where he's got some family, and he started working for Xfinity. He was a cable technician there. He did contract work. So he was able to get fairly steady work, and he was bringing in about $2,400 a month when he was doing that. His supervisor, he's still in touch with his supervisor. His name is Marvin, and Marvin works for Madison Cable Company. I assume they're a contract company with Xfinity. He has ties to the community. His girlfriend lives here, Miss Williams. They have 2 children together. They're 2 years old and 5 years old. They're both little girls, and those 2 girls live with Miss Williams. Mr. Quarles is still in close contact with Miss Williams, and they're still on good terms. So that's another thing keeping him here in the community. He has a good address. He's got a friend from college named Jacob. They went to St. John's together, and Jacob lives here in the city. Mr. Quarles feels comfortable living with him, and Jacob would be comfortable with that too. I'm sure that's 1101 Avon Avenue in Atlanta. 30310 is that address. As far as him being tied to the community outside of Miss Williams and his work, he was working a lot at the time. The times that he's been here in Atlanta. He was sentenced for a robber, but he is on probation, making him not a flight risk. He plans on abiding by all the rules of the probation. As far as the other convictions go, I mean, the null pros, I mean, he's been able to stay out of trouble, Your Honor. And so we asked that the bond be lowered, or be cut in half to, what's the math there? 12.5.
What says the state?
Yes, Your Honor, I believe this defendant is in a no bond status. I just wanted to,
Right. Yes,
okay, check if that was correct. Your Honor, the state would, understanding that he has been in longer than 90 days, that he is entitled to a bond. I understand that the state would ask that the bond be high due to the fact that this defendant does have volatile charges and picked up a subsequent charge while in custody. This means he poses as a danger to the community and there's a significant likelihood to reoffend. I'll leave it up to the court as to the amount of the high bond. We would just ask the conditions of an ankle monitor paid for by the county, 24-hour curfew with the exceptions of legal and medical be applied, no contact with the co-defendants and no contact with the victim as much as possible, as I know they're in jail.
Right. All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with your victim. Cornelius Broughton. I think that's the victim on the other one.
There were two victims.
Ms. Hollenbeck. Victim on the other one. Doo-doo. I may have left that one out. Hold on. Let's see. Cornelius Broughton, yeah, was the victim on the other one too.
Yeah.
Ms.
There-
Hollenbeck.
There's
Okay.
another victim too,
What's the other one?
Akima Gooden, Gooden.
And Akima Gooden. No further contact with Cornelius Broughton and Akima Gooden. No further contact with your co-defendants, DeAndrew King, Leo Rice, Latrell Honeycutt. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be moving. Can't break any laws, state of Georgia, sir, and you also have to let the county know if you're gonna move. Ready? $12,500 good bond. Best of luck to you, sir, and I'll still keep my promise on getting in touch with Ms. Walker, all right? Best of luck to you, sir. Thank you, Mr. Spencer. Fantastic job.
Thank you, Your Honor.
All right, you want to bring out Rice and King. Come on up, deputy.
So for King, that's Officer Simon who,
Wait, she one of them too for King? You got King on one of them, right? Yeah,
yep.
for the anything at the jail, right? Whatever happened at the jails.
So we're just doing that one.
We're gonna just do the one, yeah, at the jail
Okay.
first. Rice and King. So the officer in position one is where?
Shots fired called.
Oh, yeah. Okay, yeah, Mr. King, Mr. Luamba.
Yes.
So position one, that officer is out on a call right now for a shots fired or a shooting or something else. So this one's gonna have to be reset. If you want, maybe we can take it up, maybe we can address bond, but I guess since they're out on a call, there's nothing I can do.
Well, for DeAndrew King, Judge, he also has a $45,000 bond on an armed robbery. If we can't take up the ag, I would like to be heard on a reduction for that because he's been in there for 291 days without indictment.
Yeah, we can be heard on that bond, but we'll go ahead and take up the ag assault that happened at the jail
Okay.
because we have that deputy here. So Rice and King. Raise your right hand, deputy. You swear firm testimony about to give is truth, whole truth, nothing but the truth?
Yes, ma'am.
All right, state, spell your name in the microphone loudly for the court reporter.
I'm Deputy Sonia Pope. That's SONJAPOPE.
Can you hear that, Madam Court Reporter? Did you hear the deputy? All right.
thank you.
Now we're quick. Now we got both you guys here. All right, gentlemen, DeAndrew King. All right, DeAndrew King and DeAndre Rice, correct?
No.
All right, both of your lawyers. Well, let's see. I guess you can't see, huh? Can you see that laptop up here and see?
Yeah.
Don't turn it too much, it'll disconnect. Can you see your lawyer?
Yes, ma'am.
Okay. All right. Don't mess with it too much, it'll disconnect. We still there?
That guy here.
All right, so your lawyers are on Zoom, okay? Can you see them?
Yes, ma'am.
Okay. Because worst case scenario, Madam Prosecutor, may get you to move your stuff and let them sit there. But as long as you feel comfortable looking right there?
Yes.
Okay, all right, I appreciate it. All right. So we got 23 CP 216-419, DeAndrew King, 300 days without indictment, got a charge of aggravated assault. And got Leo DeAndre Rice at 23 CP 216-419, 316 days without indictment, 1 count of aggravated assault. All right, deputy's been sworn. Go ahead, Madam Prosecutor.
Okay. Hi, Ms. Pope, how are you?
I'm okay.
I can kind of see you a little bit. Where are you currently employed?
Fulton County Sheriff Office.
Let's see, Ms. Hemingway, Mr. Luamba, both of y'all can hear, right?
Yes, Judge.
Okay, just making sure. Go ahead.
How long have you been employed there?
Since December 2019.
Were you employed there on February 20th, 2023?
Yes, ma'am.
How did you become aware of the defendant? I understand this is about one incident, but I'm specifically referring to Mr. King, case number 23 CP 216-419.
Yes, ma'am.
I'm sorry?
What was the question?
How did you become aware
I
of
was
him?
notified by my watch commander, Lieutenant W. Carter, of the incident,
By the incident, what are you referring to?
the jail incident.
So tell me a little bit.
Assault on inmate Broughton.
Okay, I just don't want to cut you off.
Okay.
So tell me a little bit about what your watch commander said to you and informed you about this incident.
My watch commander notified me of an incident and he handed me the incident report and said an assault had occurred on the floor, and I read over the report.
And what did the report say?
The report said that Broughton identified Corals, King, Honeycutt, and King, Honeycutt, Corals, and Rice were the ones who assaulted the victim.
Who's Broughton?
Broughton is the victim.
And Broughton, first name Cornelius?
Yes, ma'am.
Okay. So the watch commander told you that the victim identified the following inmates: King, Corals, Honeycutt, and Rice as parties who assaulted him.
Yes, ma'am.
Okay. So what exactly did he say happened?
I didn't speak actually to Mr. Broughton. I didn't speak with him.
Oh, I meant the officer who you spoke to about it and gave you the
Lieutenant
report.
Carter gave me the jail incident report and I read over the jail incident report.
So what does the jail incident report say happened?
The jail incident report stated that Lieutenant Carter pulled out the victim, Broughton, and asked him to identify the inmates, which he did not. He took him to a different part inside the jail, which he did identify the 4 perpetrators, which was King, Honeycutt, Crores, and Rice.
And so by he identified them, you mean the victim in this
Yes,
case
Mr.
identified?
Broughton.
Okay. You did mention you worked at the Fulton County Sheriff's Department, correct?
Yes, ma'am.
So obviously this is in Fulton County.
Yes, ma'am.
Okay, just checking. Did you ever at any time, you or the initial officer, ever watch any video regarding this incident?
Well, the jail incident report states that Lieutenant Carter reviewed the camera footage.
Do you have any notes from what Lieutenant Carter saw?
No, ma'am.
Were any of the victims in this case injured?
Mr. Broughton was taken to medical, and I believe he was transported to Grady Hospital for treatment.
Do you know what his injuries were?
I'm not aware, no, ma'am.
But he was taken to Grady for treatment?
Yes, ma'am.
Do you know when he was brought back to the floor?
No, ma'am.
Do you know if he was gone for over a day?
No, ma'am.
In the warrant, it has that Lieutenant Carter started an interview with the alleged King, Quarles, Honeycutt, and Rice, correct?
Yes.
Did he ever give you an idea about, he said their stories were different. Did he ever give you
No, he didn't give me any details. He just said they all said different scenarios.
okay. Was there only one victim in this case?
No, there were two.
What was the other one's name?
Victim name is Gooden,
Okay.
Akima Gooden.
Did he ever speak to, the officers, Officer Franklin regarding what happened?
Not to my knowledge.
But he is mentioned in the jail incident report?
He is mentioned as a victim in the jail incident report. Yes,
Are-
ma'am.
Or were there any injuries upon him?
Not that I am aware of.
I'm sorry. Have you ever taken a look at either from their mugshot, driver's license, anything specifically of DeAndrew King?
I have, no, ma'am. You say, have I ever looked at their what again? Repeat the question.
A picture of them, any identifying information?
No, ma'am.
So how did you ID Mr. King?
How did I ID Mr. King?
Mm-hmm.
In good faith, I applied the charges based on the jail incident report that I had from my Lieutenant Carter.
And all inmates there are assigned an inmate number, correct?
Yes, ma'am.
And based upon that, in theory, you know where everyone is based upon their number, like you know what cell they're in,
Yes.
you know where they
Yes.
sleep at night, things like that. Beyond that, Mr. Broughton specifically told Officer Franklin that these are the inmates who assaulted him.
I believe the jail incident stated that he reported that to Lieutenant Carter.
I'm sorry, you're correct, Lieutenant Carter, but he did say that.
Yes, ma'am.
And then Lieutenant Carter went along and asked the defendants about it, and they had different stories as to what happened.
That's what the jail incident report states.
Okay, none of them really matching the fact that these defendants were injured. I have nothing further at this time.
All right. Ross?
Yes, how you doing, officer?
I'm okay.
That's great. Where did this alleged assault happen?
The alleged assault happened on 5 North.
5 North. Was it in a cell or out in the open?
Based on the jail, not to my knowledge, I'm not aware.
Okay, so
where
you don't know
exactly
whether
the
it happened
assault
in the cell
happened.
or in the open. Okay. The officer that reported, that gave you the information about the assault in the incident report, he never indicated the exact location outside of 5 North?
The officer, repeat the question?
He never indicated the location of the assault outside of that it was on 5 North?
Not to my knowledge.
Okay. Did he indicate it was multiple inmates charged with assaulting this individual? Did he indicate whether they all assaulted him at the same time or it was at separate times?
Based on the jail incident report, Lieutenant Carter, he made a statement that inmate Broughton, which is the victim, identified 4 of the perpetrators at one time, at a different time.
Okay, so inmate Broughton identified the perpetrators. How were the perpetrators identified? Was it a photo lineup done?
I believe based on his statement, he gave them, he put them up in a picture to where how we do our counts, and he identified the inmates that way.
You said he put them up in a picture, so he got the exact 4 inmates that inmate Broughton accused, and inmate Broughton pointed those inmates out?
And based on the jail incident report, he asked the inmates to line up. At that point, Mr. Broughton did not identify any inmates. He took them in the office. And that's when he identified the inmates based off
Okay,
of
so
their three
just so I'm clear,
cards.
the first time he asked them to line up, he did not identify him. Then he took
Based
them
off
to a
of-
second location and he did identify them.
Based off of Lieutenant Carter's statement, yes.
Okay. And the second victim in the case is Mr. What's his name? Gooding?
Gooden,
Did Mr. Gooding identify Mr. King as someone who assaulted him?
not that I am aware of.
Okay. Was there any indication that Mr. Gooding and the other victim were assaulted at the same time?
Not that I'm aware of.
Okay. And you indicated that the report doesn't state exactly what was seen on the footage.
Yes, sir.
Do you know whether or not there is actual footage of the incident?
I'm not aware.
Okay. And after the alleged victim identified my client, Mr. King, what repercussions did the jail impose on Mr. King?
Based on the jail incident report, Mr. King was charged. Mr. King was charged with assault and battery, attempting to control, failure to cooperate, and lying to an officer.
And lying to an officer. Okay. And was Mr. King or the alleged two victims moved to separate units?
Not that I am aware of.
Okay. So after someone is allegedly assaulted in the Fulton County Jail, is it typical for them to be separated and moved to different units?
From the victim, yes.
Okay, but you're not aware if that happened.
I'm not aware.
So what about the other three individuals charged with assaulting the victim along with my client, Mr. King? Were they separated and moved to other units?
Not that I am aware of.
Is it typical of Fulton County Jail to separate individuals that are charged with assaulting someone to be separated and moved to other units?
Yes, sir.
But you're not aware if that happened this time?
I'm not aware.
Okay. When the victim returned from Grady Hospital, was he put back on 5 North?
I don't have any knowledge of that,
Okay.
of his location upon arrival from Grady Hospital.
Okay. And how many jail investigations have you conducted of this manner, of this type?
I was not the investigator on this report. Lieutenant Carter, we had an initial officer. Lieutenant Carter was the investigative officer.
Okay.
And Lieutenant Walker concluded.
Okay, but yourself, how many have you ever done these types of investigations before yourself?
Not the jail incidents, no.
No jail incidents. Okay. So even though you've never conducted these types of incidents before, you took the officer's words for what happened and put the charge on Mr. King.
In good faith, and that being my supervisor, I follow orders from my supervisor.
Okay. So are you saying the standard for putting charges on an inmate are good faith based on the word of your supervisor?
No, that's not the standard, but I looked at the jail incident report and camera footage was produced.
Okay, so camera footage was produced. What was on the camera footage?
The camera footage, Lieutenant Carter did not say what was on the camera footage. So I am unaware of what was on the camera footage.
Okay, but just in good faith, because he said it was camera footage, you put the charge?
In good faith.
Okay. Was it ever indicated whether or not the alleged victim was beaten with any utensils?
Not to my knowledge.
Not to your knowledge. Who broke up the incident?
I don't know based off of my knowledge. I have no idea.
Okay. How long did the alleged beating occur?
Could you repeat the question?
How long did the alleged beating occur?
I don't know.
Okay. Is it typical for 4 inmates to jump another inmate and officers don't intervene and break it up in Fulton County Jail?
I have no information on that.
Does the incident report indicate whether or not an officer intervened?
Not to my knowledge.
Okay. So how were the officers made aware that the victim was assaulted?
In the jail incident report, DOG Franklin, she heard a group of inmates, she heard a commotion, and that's how she was alerted, based off of the initial report from the jail incident report.
Okay, so she heard a commotion. And after she heard the commotion, did she go investigate the commotion?
Yes, she did, based off of the jail incident report.
And when she investigated the commotion, what did she see upon her investigation?
Upon her investigation, she heard a commotion and one of the victims notified her. And from there, she notified the watch commanders and they also conducted their investigation.
Mm-hmm. Which victim notified her?
Excuse me, sir?
Which victim notified her?
Mr. Gooden notified her. In the jail incident report, she said that Mr. Gooden told her that he needed to go to medical, which is one of the victims in the incident.
But Mr. Gooding is also the one who said he couldn't identify who assaulted him, right?
No, Mr. Broughton.
Mr. Broughton couldn't identify who assaulted him. Okay. Did Mr. Broughton admit to being assaulted?
Did he admit to being assaulted?
Yes.
In the jail incident report, he stated that he was assaulted, yes.
Okay. I don't have any other questions, Judge.
All right. Go ahead, Ms. Hemingway.
Yes, just a few follow-up questions. Attorney Wimble covered most of it, but now prior to this, did you speak to Lieutenant Carter?
Did I speak to Lieutenant Carter prior to the incident?
Well, prior to you coming to court today about the incident?
No, ma'am.
No, you just have the report in front of
Yes,
you?
yes, ma'am.
Okay, so essentially you didn't do any of the investigations. It was just Lieutenant Carter. Is that correct?
Yes.
Okay, and your testimony today is just based off of everything that is in the police report that Lieutenant Carter did. Is that correct?
Yes.
Okay, so you didn't see any of the suspects. Is that correct?
No, ma'am.
Okay, and you didn't talk to any of them either?
No.
She said that wasn't correct. You didn't see it. You said you didn't see any of them. You said no. Did you
Well,
see it?
yes, I didn't see any of them.
You saw the videotape?
No, ma'am.
Okay.
Sorry, Miss Hemingway.
Okay, so you wouldn't be able to identify them. Is that correct?
Yes, ma'am.
Okay. Let's see. Okay. And then in regards to the assault, do you know, like, I know you said that there was an assault. What was the assault exactly?
Well, they said that the jail incident report states that Mr. Broughton was transported to Grady.
Okay, but do you know what the exact assault was, or just that he was transported to Grady?
Yeah, he was transported to Grady.
But do you know what happened? Stabbed, shot, beat, kicked?
Beat.
Okay.
Okay. Okay, so he was beat. Okay. All right, and did they say specifically who was beating? Were they all beating, or can you specify exactly who it was?
Based on the jail incident report, Mr. Broughton identified the 4 perpetrators that actually beat him.
Okay. But you don't know who they are. You've never seen them, that correct?
No, ma'am.
Okay. And did he use the word beat in the police report? Or
Not to my knowledge.
did he use the word assault?
Based off of Lieutenant Carter's
From the report?
report, he used the word that those were the 4 inmates that assaulted him.
Okay, so we don't know exactly how he was assaulted.
Not to my knowledge.
Okay,
I didn't do the report.
okay. All right. I don't have any further questions.
Anything else from the state?
Yes, Your Honor, if you wouldn't mind.
Okay,
Can you hear me?
Yes.
Okay. I'm going to go back a little bit on some of the testimony you just gave. Okay. So the inmates in the Fulton County Jail, are they in close quarters?
Yes,
Is it easy to find someone?
yes,
Have you ever seen any situations where someone might not immediately identify someone?
I have,
Is that because maybe there's a risk to them?
absolutely.
The inmates, they're all assigned numbers, is that correct?
Yes,
And the numbers are attached to their names, is that correct? Can you switch numbers and names while you're in there?
no, the inmates have no ability to switch their names and numbers.
So if I'm saying, I'm gonna use my name. If
Mhm.
I'm saying, well, if someone's saying Celeste did it, right? That's me. And they're inmate so-and-so. When the officers look it up, it's going to be me. It's not gonna be another person, right? Because there is no ability to change names and numbers in jail.
Objection, Judge. That's improper and speculative. She's given a hypothetical in order to prove a point.
So rephrase it for a hypothetical.
I'll rephrase. There is no way to change numbers and names in jail. So if
You're talking about booking numbers.
correct. I'm just trying to be mindful of the objection, so I'm trying to rephrase it the right way.
So even forming a hypothetical.
I'll move on and then I'll come back. So in the warrant that was written by you, correct? And that was based off of the jail incident report?
Yes, ma'am.
It says that Officer Franklin observed a group of inmates standing in the 5 North cell. And as an inmate saw them, I'm not sure if they're male, female, so I'll just say them. They shouted, "Here come 12." Who's 12?
That is a slang termination that the inmates use for officers.
So they're saying, "Here come the guards." So here's the problem, right?
Yes, ma'am.
It also said as the door was being opened, all the inmates dispersed. Correct?
Yes, ma'am.
You also note in this warrant that there was a big knot on the side of Cornelius Broughton's face,
Yes, ma'am.
and that Akima Gooden stated, "I need to go to medical," and it appeared he had been assaulted as well.
Yes, ma'am.
Yeah, I'm gonna object as this is leading, and it's also
It's all in the warrant. I'm not saying anything that's different from the warrant.
but she hasn't said any of this.
Well, she wrote the warrant.
Just rephrase some of your questions.
What's your title?
Deputy Sheriff.
Deputy Sheriff?
The wee bit louder for me there.
Deputy Sheriff.
Do you have to be sworn in?
Yes, ma'am.
Do all the officers at Fulton County Jail have to be sworn in?
Yes, ma'am.
And being sworn in and having an oath, is there, Do you know what that consists of, the oath?
Yes.
You don't have to give exact words, but do you have a general idea of what it consists of? Can you let us know?
The oath is you always act in your capacity and you don't deviate from that.
What do you mean act in your capacity?
You always do what is the right thing to do. When you always carry yourself with honor.
Carry yourself with honor.
Yes.
Okay. And honor. When Officer Franklin gave you the jail incident report, did you have any questions to him?
Lieutenant Carter,
Yes.
that's when he handed me the report, I read over the report.
Okay. Did you have any questions to him about the report?
I asked him how he identified the inmates, how did Mr. Broughton identify the inmates? And that's when he told me to read the report. I read the report and I asked him again, and he told me that he identified them a second time after he asked them the first time.
By their name?
Yes.
Okay.
So your lieutenant ID'd them and told you who they were from him IDing them.
From Broughton, identifying the victim.
But your lieutenant or whoever ID'd whoever it was. The defendant?
The victim, Broughton, identified them.
And then the lieutenant confirmed who it was?
Yes.
Okay.
He identified them. When I said the pictures,
Right.
we use 3 cards. You have a picture and the booking number on the 3 cards. That's how he identified them.
Okay.
Okay, you also, and this is my last set, so I'll wrap it up. You also, in your warrant state that there was security footage, but you just testified that you didn't watch it. That's correct?
Yes, ma'am.
So you're not certain also, I believe, you were asked, were the inmates separated after, and you stated that you weren't aware of that?
I wasn't aware.
So it could have happened, but you don't know the answer to that question.
Based off of protocol, they are to be separated.
But you would have no actual knowledge of that happening. But based off of protocol, that's generally what happens.
Yes.
Okay, so even though you don't directly know, in general, that's the protocol.
Yes.
Okay. Nothing further at this time.
All right, anything, Mr. Luamba?
Nothing, Judge, just argument.
All right, Ms. Hemingway?
Nothing, Your Honor, just argument as well.
All right, anything else for this deputy?
No.
All right, so deputy, on the other ones, they're reset to July the 6th at 1 p.m., okay?
July the 6th.
The other co-defendants, you got it? All right, best of luck to you. Stay safe. Thank you. Go ahead with argument.
Me, Judge?
Sure.
Yeah, thank you, Judge. I can't even believe that this case was brought. There's so many issues that makes this not reach the threshold of probable cause. First of all, we only have to go on the word of, we have the word of the officer that came to court to testify. They say that there's video of the incident, but in the incident report, there's no indication of whether or not the incident happened in a day room, in a common area, or in a cell. So we don't know whether or not these individuals are actually on video. There's no indication of whether or not the alleged victim was assaulted at the same time by my client and the other individuals, or whether it was separate. All that matters when fighting a case in regards to building a defense and in regards to building a prosecution. There's some identification issues. When the alleged victim was asked the first time, the closest in time to the actual what happened in the actual incident or identify the individuals, he did not respond. He said he didn't know. Then the lieutenant takes him to another part of the jail behind closed doors where we don't know what happened. We don't know how he identified them. We don't know whether that it was anything leading going on. And he all of a sudden identifies my client as one of the assailants. We don't know what happened after the alleged incident, whether or not that individual was brought back to the unit, or whether or not these individuals, these four defendants, were separated and moved to different pods. And so based on that, Judge, we don't have a who. The who is very skeptical because of that identification issues, because either we believe him when he said he didn't know the first time, or we believe him when he said he did know the second time. Which one is it? We don't have a who, we don't have a where. And the reason why we don't have a where is because we don't know whether it happened in a cell in a common area. And if it was on camera, Judge, I would think that the officer would put that in the incident report. I saw DeAndrew King beating an inmate on camera or exiting an inmate cell in 5 North. None of that was stated, whether they saw him entering the cell or exiting the cell. No incident report. And based on all that, Judge, the incident report is lackluster. They haven't established enough probable cause to say that Mr. DeAndrew King did anything. They don't have a who, they don't have a what, they don't have a where. They can't even tell you with the incident report whether or not the individual was hit with any type of weapons. She doesn't know. It's not indicated in the incident report. And she also said, Judge, that her putting out the warrant wasn't based on her own investigation, wasn't based on her own due diligence. Her standard for putting out a warrant and potentially depriving someone of their liberty, which is the greatest right we have in this country, was good faith. That's her standard, good faith. No investigation, no due diligence, good faith. I think just that alone doesn't meet the threshold of probable cause. If we're going around putting charges on people and arresting people based on good faith, our criminal justice system is in bad shape, Judge. And so for those reasons, I don't think that they have met their threshold for probable cause, and these charges, this charge against Mr. King should be dismissed.
All right. Go ahead, Ms. Hemingway.
Yes, Your Honor, and I'm really just gonna apply what Mr. Luwemba said regarding his client and just apply that to Mr. Rice. It is essentially the same thing. The officer that came to testify, she doesn't know anything about this case. She cannot identify who it was that was involved in the incident. I asked her specifically, can you identify who was involved in this incident? She said that she could not. And so that's definitely an issue, as well as them not having or not being able to show what the assault was. She eventually said that they were beat. However, there's nowhere in the report that states that that the word beat was used. It was just assault. We never got down to the bottom of exactly what this assault was. And Your Honor, we're just asking that you, based on those reasons, that you find that there's not enough probable cause in this case.
All right, go ahead. What says the state?
Yes, Your Honor. The state would ask that you do find probable cause. We believe there is enough probable cause for these two defendants, Mr. King and Mr. Rice. The victim himself pointed out after being instructed, or excuse me, said their names after being asked. The first time he was asked, I think as qualified by testimony, I don't know that he said he didn't know. I believe he just didn't answer. But he did identify the inmates, and the deputy came back and confirmed them. A deputy who was a sworn officer of the law, who, as my witness just stated, honor is one of them, as in telling the truth. This victim did identify both of Mr. King, and Mr. Rice, and as such, we find that probable cause has been met. We also would note that the warrant stated that there was a knot on the side of victim Broughton. And I understand that this inmate or this warrant doesn't specifically state it, but I think that the probable cause has been established that because they were in there and he pointed them out and stated, I was assaulted, I have been assaulted. I think there's enough probable cause to link both Mr. King and Mr. Rice to these charges of aggravated assault in reference to Mr. Broughton and Mr. Gooden, Akima Gooden.
All right, let's see. We got, I think both of them are on no bond. So Mr. King on 23 CP 216419 on aggravated assault, and 23 CP 216419, Leo DeAndre Rice. I find that probable cause has not been met for either account. Best of luck to you both.
Thank you, Your Honor.
Judge, can Mr. King stay out because about the bond issue?
Mr. King, you can stay out. All right, this will be. Now, both of you, just so you know, they got videos, so they get the officer that actually did it, they can still re-indict y'all. Y'all understand that, right? This doesn't mean it went away. Okay, best of luck to you. All right, Mr. King got an armed robbery, got 22 CP 211410, 300 days without indictment, armed robbery,
Your Honor,
$45,000.
I'm sorry, may I be excused?
Yes, ma'am, Miss Hemingway, good to see you again.
You too.
Right, 40, wait a minute, no, this is the one the officer's not here for, but we're gonna hear it on bond, right, Mr. Luemba?
Yes, Judge.
All right, 300 days without indictment, there's a $45,000 good bond, January 30th.
Defendant has 21 cycles. The defendant's last arrest was July the 26th, 2019 in Fulton County for possession of marijuana less than an ounce and crossing state county guard lines with weapons or intoxicants and drugs without consent. There was no disposition for that arrest. The defendant does have prior felony convictions. There was one in 2017 for Schedule 1 or Schedule 2 controlled substance. And one in 2010, he received a first offender treatment for theft by taking and entering an automobile. That case was sealed December the 1st, 2017. And there was a conviction in 2012 associated with the CWAC. Nothing in addition to felonies. He does have misdemeanor convictions. That was one in 2011 for obstruction of an officer and one in 2009 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Go ahead, Mr. Luemba.
Yes, Judge, as you said, he's been in jail for 300 days, no indictment. He does have significant ties to the community. He has 3 beautiful children. I've been in contact with his fiance weekly, trying to get up this bond money. He's not a flight risk. He doesn't have any FTAs. We don't feel like he's a danger to intimidate witnesses or danger to persons or property in the community. He will not flee the jurisdiction of the court. He simply can't make a $45,000 bond, Judge. A $45,000 bond for Mr. King is tantamount to no bond at all. He is the breadwinner for his family. He did work as a sanitation worker while he was out through Labor Ready. Labor Ready is one of those places where you can go and get a job for the day if they need you. And he will go up to Labor Ready and they will always need sanitation workers. And that's what he did for a living. He was the breadwinner for his family. All the money went to his girlfriend and his children. We're asking that because he hasn't been indicted, $45,000 bond is tantamount to no bond at all for this individual. We requesting a $15,000 bond on the armed robbery and whatever other conditions that the court deems necessary.
All right, what says the state?
Your Honor, this defendant has been given a bond, as is his constitutional right, of $45,000. Whether or not he can afford the bond is not one of the IALA factors that needs to be considered at this time. However, this defendant does serve as a danger to the community and to the victim in this case. There's also a significant flight risk based upon information as provided by pretrial. He also has 21 cycles. There's a significant likelihood to reoffend. The state would ask that you not reduce this bond, but if Your Honor is inclined to reduce this bond above the state's objection, we ask that it be no less than $25,000 with the same conditions as put on before. That was an ankle monitor with the 24-hour curfew with the exceptions of leave and medical and no contact with the victim and or co-defendants in this case. Nothing further.
Mr. Luemba, he's gonna live in Fulton County, right?
Yes, Judge.
All right. And also include this on my email to Ms. Willis, people that have been in jail this long and no indictment, just kind of as a little, hey, let's watch out for this case here. So we got no drugs unless prescribed, no alcohol, no weapons. No further contact your co-defendants, Dion Watts and Rayshawn Blue. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. That ankle monitor be paid for by the county. Sir, that is a 24-hour curfew. No further contact with Travell, T-R-E accent V-E-L-L-E, last name M-C-C-R-A-E. Stay away from 870 Mason Turner Road. $20,000 good bond. Best of luck to you, sir.
Thank you, ma'am.
Thank you. All right, so are you both here on Dodd? All right, so who wants to come up? We got the first one that's an escape. That's not you?
I'm on the escape, Judge.
What's that?
I'm on the escape.
You're on the other one too, right?
Yeah, and I saw a substitution of counsel on there with another attorney. I don't know if that's true, so I'll represent them, but.
Yes, I was gonna ask you to excuse.
Yes, thank you.
Thank you. See you tonight.
See you this evening. Thank you. Sorry, Mom didn't acknowledge you, but thank you. I didn't know if you wanted to say anything. Thank you so much. The mom, sister, whoever, I'm sorry. Thank you, guys. Your kids are very well behaved. So we got the theft by receiving stolen property and all that. Are both of you on that case? You are. Come on up to the thing. Alfred Dodd. So we'll do 3 and then you on 4? Are you on 4 for that case? He's on which case?
He's on, so this, it's the same position.
Oh, okay, just one of the counts. All right, so where's the one on the escape? Who is that? Position 4.
I'm sorry, I'm looking at 9 AM, wondering why I can't find it. Yeah, I would have to get it from my investigator.
Okay, she stepped outside. All right, so you're on the same case, just the count of crossing the guard line, right? All right. Okay. All right, how you doing, Mr. Dodd? So they're trying to figure out, so Mr. Luamba, do you think you're not on the escape charge or you are?
I know I'm on the escape charge, but for the theft charges, when I looked in the system, it said that another lawyer had filed an entry and filed a leave. So,
Okay, so that's Safa Rossi, but she did a motion to withdraw as counsel on the 1st.
oh, okay. I was okay.
So is that you then?
So it's gonna be still me then. I guess it's gonna be me.
It says it'll be assigned to a C3. Is that you?
Are
You're
you
not
talking to
a-
me, Judge?
Yeah, you're not a C3 though, are you? Mr. Luamba,
Judge?
are you a C3 attorney?
Yeah, I contract with GPDC,
Okay,
but that's what I'm saying. I was on that original case. Then when I guess he got private counsel, and then I think I was taken off.
so on this one it had, let's see. Well, it had Safa Rossi. She's a public defender. Had you
Oh, okay.
hired somebody on the case?
No, ma'am. Mr. Rossi was my attorney, but then I caught the aggravated assault in Fulton, and it has 12 other co-defendants. So
Yeah, because you were from it last week or something, right? Was it you with a bunch of other people in there with me last week or week before?
no, ma'am, it's just me. I've been in front of you by myself, ma'am.
Oh, okay.
The aggravated assault has 12 other co-defendants on it, and my original charges, I have a co-defendant on it as well. That's why they assigned me to.
All right. So do you feel comfortable going forward on this one, Mr. Luamba? Because this one,
what, Judge?
do you feel comfortable going forward on this one? It's like 22 CP 211486, theft by receiving stolen property, possession of a firearm by a convicted felon times 3, possession of a firearm during the commission of a felony times 3, seatbelt violation, VGCSA Schedule 1 or 2, crossing guard line, giving false name, and theft of mislaid property.
I can go forward on it, Judge. I don't have a problem with that.
All right, so yeah, because Ms. Alfarasi filed a motion to withdraw on on June the 1st. And then we don't have the officer here for the escape, right?
Just waiting for her to come back in. So
Okay, she's gonna ask her officer about that one. So we'll go ahead and take up that one that I just called out, and that one. Do you need to review the warrants? Oh,
I'm in,
do you need to see the warrants, Mr. Luamba?
I will, yeah.
Let's see, do you have them to email them? Let's see if I can. I might be able to email. Sometimes they go through, sometimes they don't. Let's see. Come on. Let me see.
John, I'm gonna approach my witness.
Sure. Can you put your email in the chat, Mr. Luwamba, so I can make sure I've got it? I'll see if I can't send this to you. See. All right, thank you. Yeah, always. You turn it down. You want to turn it down? You got it on someone to say. All right. You put your email in the chat?
I did, Judge.
It didn't come through there yet. Hit send. I don't know. It didn't come through. I don't know why.
Hasn't come through yet.
All right, let's see. Wait. Oh, I think. All right, now see if it came through.
Okay.
So, Mr. Dodd, that's obviously you can see that's your attorney there and on the Zoom screen here. So if you raise your right hand, officer, you swear firm testimony about to give is truth, whole truth, nothing but the truth.
Yes, ma'am.
If you state, spell your name for the court reporter.
Yes, ma'am. Officer King, work with the Atlanta Police Department.
All right, let me know when you're ready, Mr. Luwamba. You good?
I'm ready.
All right. So I've already called it off. Go ahead. What says the state? 297 days without indictment, and he has. Look. He's. As of January the 9th, 2023, he's got a $113,050 good bond. Go ahead.
Okay, Your Honor, since some of these warrants are from a different officer, do you want me to separate them out, or how would you like me to break for
So I
questioning?
guess this officer's only got 2 charges, right?
Correct.
All right, yeah, so just do his and then do the other 2.
Okay, so just for clarification, that's going to be the seatbelt violation, the theft by receiving, possession of firearm by convicted felon, possession of firearm by convicted felon, possession of firearm by convicted felon, and possession of firearm during the commission of a felony times 3. All right. Hello, Officer King.
How you doing?
I'm doing well. How are you?
I'm all right.
Where are you employed?
With the Atlanta Police Department, Zone 2,
How long have you been employed there?
since December of 2016.
Okay. How did you become aware of Mr. Dodd here?
Mr. Dodd and his co-defendant were observed operating a Volkswagen SUV on Cheshire Bridge going toward Piedmont Road. A random license plate check was conducted on their temporary plate, and it came back to a different vehicle, a Cadillac, a 2019 Cadillac.
Okay, I'm gonna stop you just really quickly. You said on Cheshire Bridge Road,
Yes, ma'am.
that's in Fulton County?
Yes, ma'am, it is.
Okay. So you can go ahead and continue.
Yes,
I
ma'am.
know it's hot in here. If you have to take your jacket off, you can feel
Oh,
free.
thank
Because it's
God.
extremely hot. Well, you don't have a jacket, but it's really hot in here. You're cold. You can take a COVID test. It is hot in here. Ooh, I'm about to die.
I've been about to faint this whole time. Okay, all right, I'm sorry to interrupt you. Go ahead. You said this is in Fulton County, correct? And you did a random license plate check. Is that typical?
Yes, it is, just to check the insurance status of vehicles operating on the road and also registration status.
Okay, so this is something you commonly do.
Yes.
Okay, so when you checked the license plate on this Cadillac, what did you find? What information was found out?
Well, I found that the license plate belonged on a Cadillac sedan. Oftentimes we see that to conceal the identity of a vehicle.
So just to be clear, because I misspoke, the vehicle you stopped was a Volkswagen, but the
Correct.
license plate came back to a Cadillac.
Correct.
Okay, continue.
Upon driving behind the Volkswagen, it abruptly turned into Tokyo Valentino. I was unable to conduct a traffic stop immediately due to traffic in that parking lot. The vehicle was observed coming out of the Tokyo Valentino parking lot, taking a right on Cheshire Bridge and pulling into the Geno's pizza parking lot. And it was at that time that a traffic stop was conducted on the vehicle.
Okay, so the Geno's Pizza, that we're still in Fulton County, is that correct?
Yes, it is.
Okay, so when you conducted the traffic stop, how many occupants of the vehicle were there?
There were 2 occupants. It was a female driver and Mr. Dodd in the passenger seat.
Okay. Did you advise them of why they had been stopped?
Yes, I did.
What did they say back to you?
I do not recall exactly what they said back. I did observe that Mr. Dodd was not utilizing his seatbelt. I did ask him for his name and he provided a false name of DeMarco Ponder, and
How
also
did you know it was a false name?
a fake date of birth. But I checked his that name in our through GCIC, didn't get any returns for that name, and also didn't find any returns through certain investigative resources that we have available to us. So at that point, he was detained and later identified himself as Alfred Dodd and was found to possess a warrant at that time.
A warrant out of where and for what?
I was out of Fulton County, Atlanta, for probation violation on a weapons offense.
I'm sorry, on a what offense?
Weapons offense.
Okay, thank you.
The vehicle VIN was obtained, and it was at that point that the vehicle was found to be stolen, and the driver was also detained.
So the driver and Mr. Dodd were detained, correct?
Correct.
Were they were taken into custody? After an individual is taken into custody, is anything done if they're driving a car regarding the vehicle?
Yes, and with this being a stolen vehicle, we conducted a search of that vehicle, and we found a Canic 9mm handgun, the middle floorboard of the back seat.
Middle floorboard of the back seat. Okay.
Right.
Okay.
And also a Diamondback 15 AR style rifle was also found in that same area. And in the trunk of the vehicle was a Glenfield shotgun, a 50-12 gauge shotgun, and several rounds of ammunition for those firearms.
Multiple guns.
Right.
Okay.
Right.
Okay, let's go back to the car. You said you did a license plate run and discovered that license plate had an indicator of being stolen, correct?
Yes, ma'am.
Okay.
The vehicle VIN.
The vehicle VIN. Did you ever ask Mr. Dodd or the co-defendant, Ms. Nicholson, about the vehicle and where did it come from or anything like that?
I did. We transported them to our Zone 2 police precinct. Ms. Nicholson was read a Miranda warning and she was asked where the vehicle came from. She notified me that a woman's boyfriend that she knows in her apartment complex in Stone Mountain let her borrow the vehicle. She didn't know their full names, but identified them as Shay and D. And she couldn't tell me the exact location of the apartment complex, but that it was located off of Memorial Drive.
She couldn't tell you the exact name of her apartment complex?
The apartment complex that she picked the vehicle up from.
Okay.
And I guess she had received the vehicle around 2:30 p.m. on that day, and in order to get food.
Does she own a vehicle?
According to Mr. Dodd, once I read him Miranda, he notified me that she did not own a vehicle.
Does Mr. Dodd own a vehicle?
I don't recall asking him if he did.
And you may not. Do you have any idea of how Miss Nicholson and Mr. Dodd know each other?
I believe he said that they were in a relationship. I did see that they have the same address on their IDs and also their driver's license.
Okay, so even if you don't know if they had a what relationship, you do know that they have the same address on their driver's license.
Right.
Okay, and did Mr. Dodd ever indicate that he knew Miss Nicholson had gone and gotten a car? Did he ever indicate any information about how this car that was stolen, how he was in it?
He did not know where that vehicle came from. He said that it was his first time seeing the vehicle on that evening. And he also stated that she normally doesn't own a vehicle.
Did they say anything to you about insurance? Like, do they have car insurance?
No, they didn't.
Okay. All right, I'm going to go back to the firearms. So you said there were multiple firearms. We've got some in the trunk. We've got some in the center floorboard. And you said Mr. Dodd was sitting in the right passenger seat. Is that correct?
Correct.
So he's in the front of the car on the right side. Were the guns, were they in his wingspan?
Yes, they were.
Did you talk to Miss Nicholson about why she was driving erratically and why she pulled into, I think you said a Tokyo Valentino and it came out really fast? Did you ask her why she was doing that?
I believe she stated that she was aware Mr. Dodd had warrants and that she didn't want to be pulled over because of that. And I guess she was worried about, she stated that Mr. Dodd was worried about the firearms that were in the back seat as well.
Okay, so Miss Nicholson indicated that he was aware of the firearms, and is that what you got from what she was saying?
Yes, ma'am.
Okay. So did you ever run a GCIC on Mr. Dodd?
Yes, a criminal history check was done on Mr. Dodd, and he was found to have been convicted of entering automobile 5/4 of 2005 in DeKalb County Superior Court.
So he's a convicted felon.
Yes, ma'am.
You said the year was 2005?
Yes, ma'am.
Okay. I'm sorry, give me 1 second. Officer King, are you post-certified?
Yes, ma'am.
Were you post-certified at the time of the incident?
Yes, I was.
You used Mr. Dodd's convicted felon status as a reason to charge him with possession of a firearm by a convicted felon?
Yes, ma'am.
And you did it 3 times because there were 3 guns?
Yes, ma'am.
Okay. I'm not gonna ask you to name the guns as they're listed in the warrant. And I don't know that I have any idea what those guns are anyway. When you stopped Ms. Nicholson and Mr. Dodd, how did they seem? What was their demeanor?
Don't recall. I would have to review body camera footage.
Okay, but you do have body camera footage.
Yes, ma'am, or at least dash camera of the incident.
Okay.
Right.
So you said Mr. Dodd initially gave you a false name and then
Right.
he gave you his real name. Was there a picture that was similar to the gentleman who was in front of you?
Of Mr. Dodd, once I obtained his driver's license picture, I was able to see that he was Alfred Dodd. I was not able to get a picture back for the false name that he provided to me.
Okay, so once you actually get his real name, the driver's license matches the person who's right in front of you, correct?
Correct.
Okay. Why don't you go ahead and tell us about your current credentials as a law enforcement officer?
Yes, I work with the field investigative unit within Zone 2. And I've worked at that assignment for the past 4 years now.
Okay. At the time that this incident occurred, were those similar to your credentials at that time? I know it was in 2022, but that wasn't too long ago. Were the same credentials?
Yes, ma'am.
Okay. Was there anything else that was recovered from the vehicle other than the firearms?
Upon a search of Mr. Dodd, several IDs that did not belong to him were located inside of his pocket.
Oh, I meant in the car.
Oh,
but-
inside of the vehicle,
Yeah.
several personal items belonging to Ms. Nicholson and Mr. Dodd were recovered. Purse and several bags. And they were later placed into property.
But when you searched Mr. Dodd, he had several IDs on him.
Yes, ma'am.
Were any of them for Alfred Dodd?
Do not recall locating one for him, just other individuals.
Okay, other IDs.
Yes, ma'am.
Did Mr. Dodd, well, you already answered this actually, but I'm going to go ahead and re-ask it in case I missed it. Did Mr. Dodd ever indicate to you that he knew where this vehicle had come from? Anything about the vehicle, where it came from, how it appeared here, what he was doing in it?
No, he did not mention that. I don't believe he knew where it came from.
But he lives with Miss Nicholson according to their driver's license.
Correct.
Okay, nothing further at this time.
All right, Ross.
Good afternoon, officer.
Hi, good afternoon.
Great. In regards to the random license plate check, is that something that you guys just do? You sit on the street and just randomly check people's license plates?
Yes, ma'am. Yes, sir. Vehicles that are operating on city streets to ensure that they are registered. And
Okay, and is there a
insurance
particular criteria which determines what cars you check?
No, sir.
Okay. So you guys just have the freedom just to run plates without any standard or criteria?
There is a case law backing it. I would have to pull up the exact case law.
When you're running those plates, do you have that case law with you?
I have reviewed it, but I don't have it with me, no.
Okay, you said that when you came upon the vehicle, they did pull over when you put the sirens on. Is that right?
Yes.
Okay, and when they pulled over, did you approach the left side of the car or the right side of the car?
I approached the right side of the car.
Did you have a partner with you?
Not on that day. No, sir.
Okay. Your dash cam was on?
Yes, sir, it was.
Was your body cam on?
Our vehicles are supposed to activate our body cameras and our dash cameras. On this day, it did not activate my body camera. I later noticed that it did not operate or activate my body camera at the precinct, and the body camera was then activated, but the dash camera was operating throughout that incident.
Okay. Did the dash cam does it have the ability to pick up the conversation between you and my client?
The dash camera doesn't, but the body camera was on and operating when Miranda was read to Mr. Dodd, and he was interviewed at the police precinct.
But during the stop, the body cam wasn't on, right?
Correct.
Okay.
And the dash camera does have the ability to pick up audio.
Did it pick up audio of this stop?
Not aware of that.
Okay. When you came upon the vehicle, you said Mr. Dodd did not have on a seatbelt. Is that right?
Correct.
Do you know whether or not he took the seatbelt off upon the car stopping, or you just assume that he didn't have it on while he was driving?
I did not observe him remove his seatbelt once the vehicle was stopped.
Okay. And you indicated that the vehicle came back stolen. Is that right?
Yes, sir. Out of the city of Atlanta.
And you also indicated in previous testimony with the state that you didn't know or aren't aware of whether or not Mr. Dodd knew the vehicle was stolen. Is that right?
Could you repeat that question for me, sir?
Do you know whether or not Mr. Dodd knew the vehicle was stolen?
I'm unable to answer that question, sir. I believe that he had some idea, being that he provided.
Your Honor, I'm going to object. He's already answered whether or not he knew the vehicle, and asking what he knew, what a defendant knew, is how is he supposed to know that?
Defendant knows.
Okay, I'll withdraw the question, Judge.
Okay.
Let me ask you this: was the vehicle? Did the vehicle have a key to it?
I don't recall whether we found the key, sir.
Okay. When you did an inventory of the vehicle, did you observe whether or not the ignition had been tampered with in any way?
I don't believe the ignition was damaged. No, sir.
Okay. Were there any windows broken out of the vehicle?
No, sir.
Okay. And Mr. Dodd was the passenger, that's right?
Yes, sir.
Okay. Now let's talk about the gun. So he was the passenger in the front seat, and maybe I missed it. Where were the three guns located again?
3 guns were in the rear floorboard in the middle portion, rear back seat floorboard.
Rear back seat floorboard. So there's under the floorboard, is there something that you could lift up and the guns were in there? When you say rear back seat floorboard, it's on there's a floorboard and you could lift up the floorboard and the guns were in there?
No, sir, it was on top of the floorboard.
Oh, so the guns were in plain view?
I believe the pistol was. The rifle, there was several bags in the back seat. The rifle was underneath the bags that were in the back seat, but still on the floorboard.
Okay. Did you guys ever do a check on the guns to determine whether or not they were stolen or who they belonged to?
We did a check on the guns, and they did not come back stolen. We do not have the capability of locating, at least I don't have the capability of locating the ownership of the firearms.
Okay. That's all I have for now, Judge.
All right, anything else from the state?
Yes, Your Honor, really quickly. You did arrest someone that day after this incident, correct?
I'm sorry, could you repeat that question?
I'm sorry, I said it fast.
Mhm.
Did you arrest someone after this incident?
After this incident?
After the stop and
other than Mr. Dodd and Miss Nicholson?
did you arrest Mr. Dodd? That's what
Oh,
I'm
yes,
asking.
ma'am. Yes, ma'am.
Okay. Do you know what Mr. Dodd looks like?
Yes, I do.
Do you see anyone in the courtroom who resembles Mr. Dodd? And if so, can you point him out with an article of clothing?
Yes, sir. Or yes, ma'am, a
You can stand up if you need to.
white and black striped shirt.
Just want the court to take note that the witness has identified Mr. Dodd sitting to my right.
All right, record reflects.
I'm gonna go back really quickly. The testimony you just gave defense counsel. You previously stated, and just to clarify, that Ms. Nicholson stated Mr. Dodd was worried about the firearms in the back.
Yes, ma'am.
Okay, so he was sitting in the front passenger right seat.
Yes, ma'am.
Which is in wingspan to the guns.
Yes, ma'am.
Okay, nothing further at this time.
All right, anything else for him, Mr. Luamba?
No, Your Honor.
All right, thank you, officer. You stay safe. We'll take you.
Thank you.
You want us to do the next one?
Yeah, come on up. All right, officer, you jump up here. You raise your right hand. Do you swear affirm testimony about to give is the truth, whole truth, nothing but the truth?
Yes, Your Honor.
All right, go ahead and state your name and spell it for the court reporter.
Officer Katori Eason.
Officer, what's that?
Katori Eason.
Okay, Officer Eason. All right, go ahead. Now, you're just here on the crossing the guard lines and schedule 1 or 2, right?
Yes, ma'am.
Yeah.
All right, go ahead.
Okay, hi, Officer Eason.
How you doing, ma'am?
I'm great. How are you?
I'm exhausted.
Samesies. Where are you currently employed?
Atlanta Police Department, Zone 2, Field Investigation Unit.
How long have you been employed there?
I've been with the Atlanta Police Department since November 2016.
Okay. How did you become aware of Mr. Dodd?
Me and Officer King are on the same unit. So whenever one of us gets a case that may take a significant amount of time, we basically all come together and we try to divvy up different responsibilities so that way we can handle it quicker.
Okay, so what responsibility did you handle that specifically involved Mr. Dodd?
Transportation to the jail.
Okay, was that on or about August 14th, 2022?
Yes, ma'am.
And because you work for APD, I'm assuming we're in Fulton County, correct?
Yes, ma'am.
Okay. When you transferred Mr. Dodd, what happened?
As soon as we got to the Fulton County Jail, in the Sallyport, he was interviewed by one of the correctional officers. They do a short and basic interview. They basically asked them if they were harmed anyway, if they're involved in a car accident, if they've been around anyone with COVID, things of that nature. Afterwards, they're walked into the holding area for searching. That's when Correction Officer D. Lott commenced a standard strip search for them.
And a strip search, what does that imply? That's completely nude? Is there?
Yes, ma'am.
Is
There's
it-
a holding room that they're allowed to go into. After they take off each level of clothing they take off, they hand it to the corrections officer. That corrections officer searches throughout that entirety of that clothing. And then once they've stripped completely, he hands the clothing back and they put the clothing back on.
Okay, so how many correction officers would you say are typically in the room when that's done? You said you have one who's actually going through the items of clothing and one instructing the.
No, just be me.
Okay.
Any other officers that are bringing in a arrestee, as well as one corrections officer.
Okay, so were you there when Mr. Dodd was getting searched?
Yes, ma'am. I was standing outside the door. Mr. Dodd was inside the room. Every time he took off a layer of clothing, he would hand it outside the door to the corrections officer who was standing in front of me, and that corrections officer would go through the clothing.
Okay, was anything found?
Yes, when Mr. Dodd took off his, he had a black Pittsburgh Pirate like baseball cap. He handed that to the corrections officer. When the corrections officer searched it, he found a small like clear plastic baggie in the inside lining of the ball cap. And once I looked at it, I knew that it was crystal methamphetamine. Once weighed, it was, I believe it was like 0.36 grams.
Okay, how do you know it was meth?
My extensive training and experience with it.
Tell me a little bit about that.
So the meth that he had was in crystallized form. Basically, It's called ice as a slang terminology on the street because that's what it looks like as far as clarity. But if you look at it in the crystallized form, it looks like a small table salt.
And you're gonna have to give me approximately how many times have you dealt with things involving narcotics? Not meth specific, just
Meth specific. Well, I could give you meth specific. Meth specific, probably about like 30, 40 times. Drugs, close to the couple, maybe hundreds.
okay. This is not your first rodeo, is your point, right?
Oh man.
Are you post certified?
Yes, ma'am.
Were you post certified at that time?
Yes, ma'am.
Okay, so is the procedure of the strip search, is that typical?
Yes, ma'am.
Was there anything atypical about the search that was done, other than the fact, obviously, that you located crystal meth? Was there anything abnormal, or was it standard procedure?
It was pretty standard, ma'am. I believe the corrections officer had his camera with him too. So it's possible that Fulton County has the camera footage, but Atlanta police wouldn't have access to that.
Okay. Do you see the person in the courtroom that was strip searched at that time and crystal meth was found in the hat?
Stand up if you need to.
Yes, ma'am.
Can you identify him with an article of clothing?
He's wearing a black and white striped shirt.
The court to reflect that the witness has identified Mr. Dodd.
All right, the court's record reflects. Go ahead.
So what did you do with the drugs?
Well, after Corrections Officer Lott gave them to me, I put them in the rear of the patrol vehicle because you can't take them inside the jail.
Can't take what? Be specific.
You can't take any drugs or any form of contraband inside the jail.
Okay.
Afterwards, after Mr. Dodd was done with his intake process, as far as medical screening and his search, I, at that point, did the warrants for possession of a scheduled substance as well as crossing the guard line.
Was the meth ever sent to be tested?
Yeah, all scheduled substances outside of less than an ounce of marijuana is sent to the GBI and tested.
And that's typical procedure?
Yes, ma'am.
Do you have the results, or are they still pending?
I don't believe the results are pending, but I do not have those results. They don't send them to us individually.
Okay. How are you aware that meth is a Schedule 1 or 2?
Honestly, extensive experience.
Okay. So again, not your first rodeo at it.
No, ma'am.
Okay, you mentioned that the drugs were in a lining inside the fabric.
So it's the inner lining. Basically, like if you look at a regular ball cap,
Okay.
they have a elastic inner lining band. It was tucked in between the ball cap itself and the elastic band on the inside. So you can fold that band down I don't know if you wear baseball hats. But
I don't.
yes, there's an inner elastic band on the inside of most baseball hats that keeps
Okay.
that snug fit. You can actually fold it down as well. So inside that lining is where it was.
Okay, but even though I don't wear baseball caps, it's a personal place where it's in, right? It's not
Yes,
something
ma'am.
that everyone would have access to, correct?
No, ma'am, unless you gave it to somebody and they just decided to do it, which I don't understand why anybody would do that.
And the hat was on Mr. Dodd
Yes, ma'am.
when he was detained, and he's getting searched by you, so the drugs are on him while he's getting detained, correct?
Yes, ma'am.
And
He
is
was
that why you
arrested.
charged him with crossing guard lines of a correctional institution with prohibited items?
Yes, ma'am. And also, before we even transport anybody, we always ask if they have anything on their person.
Did Mr. Dodd indicate that he did or didn't?
No, ma'am.
He didn't indicate, or he said, no, he didn't?
Oh, he said no, he didn't.
Okay. Well. By the time you interacted with Mr. Dodd, did he ever give you a false name, or did he say his name was Mr. Dodd?
He never identified himself by name.
Okay, but Mr. King, who you work close with, he told you who he was.
Yes, ma'am.
Did Mr. King indicate to you that he had previously given a false name?
No, ma'am.
Okay, not at that time?
No, ma'am.
Okay, nothing further at this time.
All right, Cross.
Yes, good afternoon, officer.
Good afternoon, sir.
So you said when you searched Mr. Dodd, when y'all got to the jail, you found some crystal meth in his hat?
No, sir, I didn't search him. He was searched by Fulton County Correctional Officer at the jail. Anytime we transport an officer to the jail, a corrections officer is the one who searches.
Okay, and they found the meth and handed it to you?
Yes, sir.
Okay, and you, based on your professional experience, you believe that you can look at a substance and determine what it is without having test results?
In reference to certain substances, so heroin, crack cocaine, crystal meth, and marijuana, yes, sir.
Okay, and based on your observation of what you believe to be crystal meth, you decided to charge him with purchase, possession, or have control of contraband substance schedule 1 or 2?
Yes, sir.
Okay, is it typical of you to put drug charges on people without confirmation that there's actually drugs?
Yes, sir. Unfortunately, we don't have any testing facilities within the city of Atlanta to do so. As far as field test kits, the department does not use those.
Okay.
So everything done as far as identification is either done by admission or training and experience.
Training and experience, okay.
Yes, sir.
And as the state indicated, to this day, you don't know exactly what the substance was because the tests haven't come back. Or you don't have them.
Yes, it's fully possible that the tests were already done and the results have come back, but they weren't sent to me directly.
Okay.
You basically you have to do a physical inquiry. So I believe it's you have to send an email off to the GBI, or you have to submit some form of paperwork for them to give you the results back to a specific individual. The results do come back, but I believe the results are sent to the annex where they're initially picked up.
I don't have any other questions, Judge.
All right, anything else from the state?
Just two questions. I know we talked about your experience. Oh,
I'm sorry, can you hear me now? Court reporter? I'm gonna assume yes.
Yes.
We talked about your experience a little bit. You indicated to me that you worked with meth 34 times, so you've seen methamphetamine, right?
Yes, in all forms.
So you've seen it in a crystallized form?
Crystal, liquid, powder. Yes, ma'am.
I didn't even know it could be a liquid.
Yes,
So how does crystallized methamphetamine in physical appearance differ from, let's say, crack cocaine in physical appearance?
Crack cocaine is cloudy. Crystal methamphetamine is, in the terminology itself, crystal. So it's pretty clear, which is why they call it ice as a slang term on streets.
Okay, so this item that you found in Mr. Dodd's hat, this was clear in color, correct?
Yes, ma'am.
And that's what led you to believe that this is crystallized meth, excuse me. Is that correct?
Yes, ma'am.
And you've done approximately 34 times you've dealt with methamphetamines, and some of those are in crystallized form.
Yes, ma'am.
Okay, nothing further.
Anything else, Mr. Luwamba?
Yes, just one more thing. In your 34, 40 times of dealing with crystal meth and narcotics, have you ever seen counterfeit crystal meth, fake crystal meth?
No, sir. Generally, if it's any form of crystal meth, it may not be counterfeit, but they may cut it with another agent to make it more potent. But you'll never truly find somebody either in possession of or even really selling false crystallized methamphetamine, because you can also smell it. If you put it to your nose, which I mean, I don't recommend, but it does have an odor to it. It's kind of like a musty chemical smell. Most people who use it or have dealings with it recognize that smell if you do put it to your nose.
Okay. No other questions, Judge?
Anything else from the state? Can the officers be excused?
Yes.
Y'all stay safe. All right, go ahead with the argument.
For both of the officers, Judge, all
Yeah, because it was
charges?
just the one case. We don't have the officer here for the escape.
Okay. All right. Yeah. So, Judge, I'm gonna start with the theft by receiving stolen property, Judge, the one that the first officer testified to. One of the main elements of theft by receiving stolen property, Judge, is knew or should have known. Knew or should have known is very, very important with this. Mr. Dodd, according to the officer, was the passenger in the car. There was no indication that the vehicle was stolen. No windows broken. No tampering with the ignition. According to the officer, the girlfriend borrowed the car from somebody at an apartment complex on Memorial Drive. Mr. Dodd, there's no reason why he knew or should have known that that vehicle was stolen. Being a passenger in a stolen vehicle doesn't automatically impose upon you the presumption that you knew or should have known the vehicle was stolen, especially when there are no physical indications that the vehicle was stolen. So because of that, Judge, I don't think because they missed that element, I don't think that they met their probable cause burden to charge Mr. Dodd with theft by receiving stolen property. In regard to the guns, Judge, a felon in possession of a firearm, the only argument that I have for that is I haven't seen the vehicle. I don't know whether or not Mr. Dodd was in the wingspan of these firearms. So just based on that alone, I'm going to argue that they haven't met their probable cause. Make a limited argument for that because I would have to measure Mr. Dodd's arms and see how big the vehicle was. So for that one, Judge, I'm just going to have to make a minimal argument on that. I'm gonna move to the drugs. Now, on the possession of the Schedule 1 substance, Your Honor, I can't believe this officer just admitted that he charges people with possession of drugs just based on observation. I can't believe that. We're talking about a serious charge put on somebody because he said he can eyeball it. He doesn't have a field test kit. A field test kit is very simple and would determine whether or not he has an illegal substance on him or not. And we don't have the results of that drug test either, Judge. We're here a lot of days after this particular incident happened, and we still don't have the results of the drug test. The state doesn't have the results of the drug test. Only indication that we have that it was alleged drugs was because it looked like something. And to put a charge on somebody because something looks like something isn't a good investigation. They should have either waited till they could get it tested. They have the tools to do that, or not put the charge on him at all, or retain it, keep it in evidence, and then put the charge on him later. They didn't do that. They hastily charged him with something that they don't know what it is. That's just like charging someone with possession of a firearm by a convicted felon. It's a fake gun just because you see it's a gun and not testing the gun. It could be a plastic gun. So I think that's a little futile. And because they didn't know what it is and still don't know what it is, crossing the guard lines, that charge, they don't meet probable cause for that because we don't know what he crossed the guard lines with because there wasn't a test done. So all we know is that a substance was found on him that he's recognized as ICE based on his experience, but it hasn't been tested. It hasn't been corroborated. So therefore, the theft by receiving stolen property for the vehicle, they haven't met their probable cause with that because there's no testimony that he knew or should have known that it was stolen. And the possession of the Schedule 1 drugs, there's no probable cause for that because he didn't test it. We don't know what it was. Therefore, the crossing of the guard lines with the contraband charge should also be dismissed because we don't know if it was contraband. That's a simple investigation that they have to do, and they didn't go over and beyond to do that. So because of that, we don't concede to the theft by receiving stolen property, the drug charge, or the crossing guard lines with an illegal substance charge, Judge.
All right, go ahead. What says the state?
Yes, Your Honor, I'm going to start with the bottom charges. The state would submit to the evidence that was submitted on the VGCSA and the crossing guard lines of a correctional institution with prohibited items. As the officer testified, he has had plenty of experience with this, and he himself has dealt with crystal meth. He understood the difference between crystal meth and another drug that might have similar components, and he himself, who was a sworn officer of the law, and with plenty of experience in narcotics, stated that this item was crystal meth. In reference to the theft by receiving stolen property and the defense's allegation that probable cause has not been met, in the warrant, it states that one, Mr. Dodd and Ms. Nicholson do live together and that he wasn't aware of Ms. Nicholson owning or having a vehicle at that time. The first time he'd ever seen the vehicle was that night. Previous officer also testified that that he didn't know whether or not car insurance was established. Based upon that, I believe probable cause has been met. For the possession of firearm by convicted felon, well, the defendant is a convicted felon. There were firearms in the vehicle, and the officer testified it was in his wingspan. While I have not gotten in the car myself, a Volkswagen is a smaller car, and based upon that, it would definitely be in his wingspan. For the possession of firearm or knife during commission of certain felonies. That attaches with the firearm and the convicted felon charges and the theft by receiving stolen property. Again, the state would submit to the evidence and testimony given by both Officer King and Officer Eason. Nothing further.
All right, I'll find probable cause on everything. Ms. Jackson, preach. Rah.
For Mr. Dodd, Your Honor.
Yes, ma'am, Ms. Jackson.
All right, the defendant has 35 cycles. The defendant's last arrest was March the 12th, 2021 in Fulton County for a probation violation. It does appear to be on probation in Fulton County for theft by receiving stolen property. That case number is 17 SC 154306. That disposition date was October the 29th, 2019, and the term is for 5 years. He does appear to have a history of failure to appears. There was one in 2019, one in 2018, and one in 2015. And he does have prior felony convictions. So one in 2016 out of Banks County, Georgia, for possession of a firearm by a convicted felon. So one in 2007 out of Newton County for possession of cocaine and possession of controlled substance. And there was one in 2007 out of DeKalb County for theft by receiving stolen property. And there was one in 2009 out of Barrow County for theft by taking. And there was one in 2005 out of DeKalb County for entering an automobile. An additional one in 2005 out of DeKalb County for theft by receiving stolen property. There was one in 2004 out of Rockdale County for theft by receiving stolen property. And there was one in additional one in 2004 out of Newton County for theft by receiving stolen property. The defendant does have misdemeanor convictions. So one in 2015 out of Cobb County for driving while license suspended or revoked and giving false information to an officer. And one in 2012 out of DeKalb County for driving while license suspended or revoked and possession of marijuana less than an ounce. Nothing in addition, Your Honor.
All right, go ahead, Mr. Lumumba.
Yes, Judge, I believe he has you stated $133,000 bond on all the charges that were just bound over.
113.50.
Oh, my bad. Excuse me. $113,050 bond on the charges that were just bound over. He can't make that. He's been in jail for over 300 days without an indictment. I know that he has a semi-lengthy criminal record, but I can tell you that Mr. Dodd does have a loving family. I can tell you that because they call me all the time trying to find out what's going on with his case and can we get this bond reduced. Based on the fact that he is still innocent until proven guilty of these charges. So as of right now, his only criminal history is what he's been convicted of, and he's been in jail for in excess of 300 days, which is egregious in Fulton County Jail. We're requesting that his bond be reduced to a $60,000 bond on all charges. And yeah, we're requesting that his bond be reduced to a $60,000 bond on all charges. We don't believe that he is a flight risk. We don't believe that he is a danger to commit future felonies or that he will intimidate witnesses. We just asking that the court put on any restrictions that they want on Mr. Dodd upon release, if he can make this bond, in order to give him an opportunity to fight these charges from the community, because he's been fighting them for the past 300 days in jail without indictment, without any real movement on his case.
All right, what says the state?
Your Honor, this defendant does have a bond attached to him, as is his right by constitution. 113, we would ask that 113,50,000, a good bond be left in place due to the defendant's history. I believe pretrial mentioned he also had numerous FTAs, therefore this defendant serves as a flight risk. She also mentioned numerous theft by receiving charges. That in itself poses as a significant likelihood to reoffend. If Your Honor is inclined to lower the bond above the state's objection, we ask that it be no less than 85,000, with conditions of an ankle monitor, 24-hour curfew, with the exception of legal and medical, no weapons while out on bond, no drugs while out on bond, without legal prescription. And I think that's it. I'm
All right.
tired.
Are you gonna live in Fulton County, sir?
Yeah.
Yes.
Yes, ma'am.
Okay, all right. No drugs unless prescribed, no alcohol, no weapons. You're gonna have ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical appointments, and also employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You also have to supply an address where you're going to be living. All right, no further contact with your co-defendant, Sequoia, Saquoya Nicholson, Nicholson. Stay away from 1903 Piedmont Road in Atlanta, Georgia. No further contact with Craig Bossen, Bossen. All right, so we got 5,000, 7,000, 7,000, 7,000, 7,000, 7,000, 7,000. Seatbelt violation, UJR through the jail, then 3,000, 3,000, false name, UJR through the jail, theft of lost or middle-aged property, UJR through the jail. You got that, Ms. Hollenbeck?
And no, you went fast at 7,000, 7,000. That's what you lost.
5,000, 5,000, 7,000, 7,000, 7,000, 7,000, 7,000, 7,000. So it's basically 7 on all the firearms, UJR on the seatbelt, 3 on the VGCSA, 3 on the guard line, UJR on the given false name, and UJR on theft of lost or mislaid property, and 5 on the stolen property. 5, 7, 7, 7, 7, 7, 7, UJR 3, 3, UJR.
Put your hand down.
Okay, I got it. Thank you.
I'll come.
All right. All right. Best of luck to you, sir. Yes, sir.
I'm trying to ask about the attempted escape. You remember last time I came, you said he was gonna try to give me a bond on that.
Yes, sir. So, Mr. Lumumba, you want to go ahead and be heard on bond since we don't have, why didn't the officer here on the escape? Do we not have him subpoenaed? What?
We've asked the officer to call in reference to a subpoena. If your honor is inclined to reset it, I can try to, even if it's by Friday, to not delay, I can see if I can try to get it by Friday.
I still want to be heard on bond. I mean,
Yeah, we could go ahead and be heard on bond. Why don't you go ahead, because before it needed a C3. So now he's been appointed, but we need to get officers. So this would be the only reset left for an officer.
Understood.
Ms. Hollenbeck, this will be the last reset for an officer, but we'll go ahead and be heard on bond. Go ahead, Mr. Luamba.
Judge, for all the previous reasons that I cited about why his bond should be reduced, and thank you for reducing it. I believe it was 85,000. We're going to ask for $1,000 bond on the escape, Judge, to add to the other, and with the same bond conditions. He has been in jail for 300 days. A lot of times, Judge, these individuals can be charged with escape for not being in their cell. What we do know is he didn't run out and hop over a fence. We do know he didn't rush a door and try to get out of the jail. We do know that he didn't run to another unit. I've seen this plenty of times. They charge people with escape for the most minute things, not being where they're supposed to be and things of that nature. So we're asking for $1,000 bond on that to bring the total bond to 86,000.
All right. What says the state?
I was trying to find, your honor, what was the bond currently set at? Because
bond.
No bond for the escape charge.
Right.
Okay. I'm sorry. Your honor, we would ask that because the defendant has been in jail over 90 days, he is entitled to a bond. We would ask that your honor set it as a high bond. The warrant states that he ran out the 911 emergency door and ran up the stairs, but was later apprehended. Previous reasonings that I mentioned before, also due to the fact that he's in jail and still breaking the law, I think serves as a significant likelihood to reoffend. The state would leave it into the court's discretion as to setting a bond amount.
All right. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, exact location you're going to be working. You also need to let the ankle monitoring company and the clerk, which is your lawyer, know where you're going to be living. All right. And no trying to escape. $5,000 good bond. Best of luck to you, sir. And we'll put that back on for, what do you want, the escape, 2 weeks?
If you could, your honor.
A week. Ms. Watts, what's that? Let Mr. Luamba check his schedule.
Yeah, 2 weeks.
Can we do June 20th at 1 p.m.?
June 20th at 1 p.m., Mr. Luamba?
June 20th. Is that a day you have night court too, Judge? If we could do night, that would be better, or no?
Well, I don't do these, I don't do prelims at night.
Oh, I'm sorry. Okay.
No, it's okay. I know it
Can
would
I
be
email your office, Judge?
about a date.
Yeah, because my phone's I write all my stuff out. It's not in a phone.
Yeah, I got you. I got a paper counter too. So Ms. Watts, will you email him and he can email you back? Yeah, just email Ms. Watts back. She emailed you and let her know what date works for you.
Okay, great.
Okay. All right, that's it. Thank you. Ms. Hollenbeck, you got everything?
Yes, I got everything.
All right. Thank you, Mr. Wamba. See you later.
Thank you, Judge.
And best of luck to you, Mr. Dodd.
Yeah, thank you.